Good morning, Your Honor.
Good morning.
Morning.
Good morning.
Morning.
Good morning.
Good morning, Your Honor.
Good morning, ladies and gentlemen. The 250th District Court of Travis County is now in
Morning.
session. Karin Crump presiding.
Welcome to the 250th District Court. If you would, please mute your microphones for me while I call through the docket, and only unmute when you are ready to make your announcement for the record. Today is Friday the 14th, and we are streaming live on the court's YouTube channel in order to adhere with the open court's provision of Texas Constitution, although I'm here at the CFCF at 1700 Guadalupe Street. And all of you are welcome to be here, but all of you have chosen to appear remotely this morning. And I am going to call through first with D1 GN 20007462 Swift Financial LLC versus McDaniel. Who's here on that case? You're muted, so just make sure you also unmute when you're ready to speak with the court. Thank you.
Yeah, Your Honor, Jay Dushkin on behalf of Swift Financial.
All right, good morning. And you're here, and I don't see the defendants in the courtroom, though our court did confirm this morning that the defendants have been served. Is that correct?
That is correct. They
Okay.
served last night or yesterday afternoon, some answers to the interrogatories. They were probably half filled out, did not answer any of the requests for production, and did not produce a single piece of paper.
Okay. And I see the show cause in the court's file that it looks like Judge Gantu Hexel signed ordering the appearance here this morning at 9 a.m. by Xenia Events and Frederick McDaniel. And so what are you asking the court to do this morning?
Your Honor, I'm gonna talk to my client to see if they want to do the writ of attachment.
Okay.
And what I would do is I would file that. And I'm gonna contact the defendant and explain to him what's wrong, show him a copy of the order of attachment, and try to get him to just provide us the information we need. But if we don't, then I will submit the writ of attachment and go down that path. So in other words, I don't really need anything today except maybe making a note that we're probably entitled to a writ of attachment, and that the counsel will contact the defendants and may submit it in the next month or two.
Okay, what I'll do is I will indicate in the court docket notes, or the court will note that you appeared this morning, but neither of the defendants appeared despite an order for show cause signed by Judge Gantu Hexel, and that the court will consider future action if and when it is requested. Okay, Mr. Dushkin?
Yes, may I be excused?
You're excused. Have a good rest of your day.
Thank you. Have a good weekend.
Take care. Bye-bye. The next case is Rocket Mortgage versus Kokaris, Demetrius, and occupants. This is a motion for default judgment. Who's here on GN 22006896?
Good morning, Your Honor. Rachel Donley on behalf of Rocket Mortgage.
Good morning. How are you?
I'm doing okay. And yourself?
Good.
Good.
It looks like we have no appearance from the defendants, correct?
No, Your Honor, it's a default.
Okay, and it looks like, let me walk through that one in just a bit.
Yes, Your Honor.
Okay, that'll take some time. So I'm going to come back to you. How much time?
Okay.
Do you need? 5 minutes or so is what you
Yes, Your Honor.
announced. But it will take the court some time to walk through and make sure that everything is in order. So that's why I'm going to put you a little bit further back. You're welcome
Okay.
to go into the breakout room if you wish to do that, but we do
Okay.
need time. Before I let you go, I want to make sure that I have what I need before I go.
Yes, Your Honor.
Okay, thank you. Okay, Elia Gomez and Medlift, GN 21004520 is next on my docket. Who's here on that one?
Stephen Hooker on behalf of the plaintiff, Your Honor, Elia Gomez.
Good morning.
Good morning.
Are you here just to announce an agreement or do you have your opposing attorney?
The opposing attorney was with us, Mr. House. Looks like he's still here, but we are just simply announcing an agreement, Your Honor.
Okay, you don't need any assistance from the court today?
I simply wanted to memorialize our agreement and put that on the record, and then that should suffice.
Okay, you are welcome to do that. Mr. House, can you hear me?
Yes, ma'am.
Good morning.
Sorry, I had to figure out how to unmute.
Oh, no problem. Okay, I understand you all have an agreement. Are you ready to read that into the record?
Yes,
I
Your
am,
Honor.
Your Honor.
Okay, and who's going to do that? Mr. Hooker, is that you?
Yes, ma'am.
All right, we have Ms. Foley, the court's official court reporter here with us in the courtroom, and you may proceed, Mr. Hooker.
Prior to today's hearing, the representatives for the parties, Elia Gomez and defense for Mary Mendoza and Medlift, came to an agreement on the deposition of a corporate representative from Medlift. And what Mr. House has represented and agreed to is that his office will provide a range of dates in June of 2023 to either take the deposition of the corporate representative or take a CNA, which is a certified non-appearance. John, did I encapsulate that correctly?
That's correct and agreed to by defendants.
Okay, very good. Well, you have your record, and unless you need anything else from me, you're excused, and I hope you have a great weekend.
Thank you, Your Honor.
The docket notes will reflect that you reached an agreement this morning.
Thank you.
Oh, best of luck. Take care. Next case is the Nunes matter was asked to reschedule once some other issues had been addressed, and so they will not be here this morning. That was GN 20-003770. The court's staff attorney notified the parties that they did not have to appear because of those deficiencies. The next case is GN 21-001846, Derry Edmondson and Audubon Freight Lines. Who's here on that case?
Good morning.
Linda Meltzer for the movement, Sarmad Morrow and Audubon Freight Lines.
Thomas Kasurg for the plaintiff and respondent.
Good morning.
Greg Peterson for a counter defendant.
Okay. You will have a motion to compel and a motion to quash, correct?
Yes, Your
Your
Honor.
Honor, we've reached agreement on the motion to compel, and we've also narrowed the scope of the motion to quash. There were 8 deposition topics that we had objected to. We've reached agreement on 4 of them.
Okay, very good. If you all will hold tight for me for just a moment, I'm going to turn to the last case that's set before me this morning, and that is Austin Arnold versus Omni Hotel Management Corporation. Good
Robert
morning.
Melendez. Yes, we're here, Your Honor. Robert Melendez on behalf of the plaintiff.
Good morning.
Morning.
Good morning, Your Honor. Chris Blanton on behalf of Omni.
Good morning. How are you all?
We are great.
We're
Good.
living the dream.
Living the dream on a Friday morning. Very good. You all are actually here before me because you have a motion for summary judgment, but you are also set for docket call today. So I'm going to begin and go ahead and get from you before I wrap up the 2 other matters that should be fairly quick and get to you all on the summary judgment. So first I need to know from you with respect to your jury trial, which is scheduled a week from Monday. Are you both ready?
Plaintiffs are ready.
Defense is not ready, Your Honor. We have a pending motion for continuance, a verified motion for continuance filed with the clerk. And we're announcing not ready and would like to be heard with respect to that continuance as well.
Okay, and will you benefit from some time to work together before I get to your summary judgment and motion for continuance?
Mr. Melendez and I have worked well together throughout the course of this case. And to the extent we could have reached agreements, we would have. So I think that Mr. Melendez and I would both be in agreement that some time together would not be beneficial or not be fruitful.
Okay, why don't you just summarize for me the basis of your motion for continuance?
The basis for my motion, or for Omni's motion to continue, is that the case is not ready for trial. Depositions continue. This is a case in which the plaintiffs have a demand of about $10 million for a back fracture. And the plaintiffs themselves have a deposition scheduled for next week of their primary principal pain management physician who forms the backbone, not pun intended, for their damages model. And we have several depositions that we still need to take. And if the court, and the basis is we have additional discovery that needs to be concluded. We have outlined pursuant to the rules those depositions that need to occur and where we need to go with that. Additionally, if the court were to carry us over into a second week for this trial, I learned last night that my liability expert has surgery planned. This was new to me as of last night, that if we were to be carried over for a second week of a setting, that he would be unavailable. Third and finally and foremost, forget the obvious thing, lead counsel in this case is Kyle Briscoe with my firm. And Mr. Briscoe has two conflicting settings, one of which is a federal setting, and it is set to go. The case has not resolved, and it will go unless there's a resolution reached. And there is an additional state setting that is set and is an older case and has not settled.
And when you say a setting, are we talking about a trial setting or a hearing, or what's set?
Yeah, yes, Your Honor. But both cases, in both of the cases I mentioned, they're both trial settings.
Okay, Mr. Melendez, your response on the motion for continuance request.
So I can't disagree that we are trying to get a lot done prior to trial. It is true that I am deposing by agreement, however, the main pain management doctor on Monday. And so, transcripts are going to be rushed. I still think we can get it done. I'm not going to tell you, Judge, that there isn't more discovery that we're trying to do at the last minute. But my client is adamant about not wanting this case continued anymore. And so again, all this discovery has been done by agreement. The case has been set a long time ago. I think they know their calendaring, but that's my response.
Okay. Has this case been continued before?
I don't believe there's been a formal, I don't believe that, Robert, correct me if I'm wrong, I don't believe there's ever been a formal motion to continue filed.
I just don't remember. I'm sorry.
I don't believe a motion to continue, Your Honor, has been filed ever.
Okay, let me ask you this. Have you all looked at your calendars to see that if the court granted the continuance and provided some additional time to complete discovery, to move to a week on which there aren't any conflicts with surgery of experts or attorney trial conflicts, on which date are you asking the court to continue your trial, Mr. Blanton, if you have a date in mind?
I would look for the first weekend of September. I know that, or the first week, excuse me, Your Honor, the first week of September. I know my September is wide open.
The first jury week in September.
Yes, Your Honor.
Okay.
So
And is the 7th, Mr. Melendez?
the 7th?
September 7th.
Do you mean 4th?
September 18th, actually.
Okay. Let's see. 18th. I'm set, Your Honor. I'm set on Beltran versus J.E. Dunn Construction. That one's already on the docket. Unfortunately, I'm not available that week.
Okay. What about backing up to August 21st?
Defense is available.
I'm set again, Your Honor, on Ada German versus LAZ Parking. And that one we reset already to make sure that we didn't get bumped. I'm not available, but maybe sooner than that.
The week The jury week before that is August 7th. And
That works with defense.
okay, and then before that is July 24.
I'm set August 7th, Your Honor. That is Francisco Chavez versus Mohawk Concrete Pumping and Perry Homes. And then you said before that was July what?
24.
I'm set again, Your Honor. That's Martinez versus Cedillo for July 24th. I'm set that week as well.
June 26th. I think May.
June 26th will work, Your Honor. Even though I am set, I know for sure we're going to have to continue that case. It'll be our first continuance. That is Salinas versus Gonzalez. So even though that would make me double set, I'll move to continue the June 26th trial for a couple of reasons, including Mr. Arnold's going to be living. And so I'll move the June 26th trial.
Okay, Mr. Blanton, how's that one look for you all?
That's the bee's knees, Your Honor.
That's it. Ding, ding. Okay. The court will grant the continuance until June 26. You have a 2019 case, so I would expect that you are going to be pretty well situated to go to trial on that date.
Great.
The age of the case, and given the continuance here today and the agreement of the parties, and that it's summertime, and a lot of people don't like to have jury trials in the summertime. So I think that you probably should be in very good shape to go. So be ready for that. That gives you some extra time to complete discovery and clear all the calendars and be ready. Okay.
Excellent.
You still have your motion for summary judgment, so don't leave, but I'm going to go ahead and attend to the others on their issue, but you can let everyone know who you need to let know. And the court's going to let Judge Meacham know that I've granted your continuance until June 26th. Okay.
Okay.
Thank
Super.
you, Your Honor.
Thank you.
See you shortly.
Before we let you go, do you know how many days you'll need? Do you think you're going to go into a second week?
No, ma'am. I believe, Robert, would you agree with me that it's probably going to be 4 to 5 days?
Yeah, I think it's going to be 5 days because I'm going to need 3. And I don't think you're going to need more than 2.
Yeah, I think that's correct.
Okay, we'll let them know that you just need 1 week till June 26th. Okay.
Okay.
Okay. Thank you all. See you in just a little bit. All right.
Crump.
Go back and let me take care of the Edmondson Audubon matter. Welcome back.
Thank you, Your Honor.
Thanks for your patience. I've got Judge Meacham's court doing docket call, and I want to make sure that they had the information that they needed for that matter. So let's go to your case, and you may proceed when you're ready.
Thank you, Your Honor. The remaining issue before the court is the defendant's motion to quash some topics notice for a corporate rep deposition taking place next week. There were 38 topics originally for that deposition notice. We objected to 8. We're down to 4. So the remaining topics that we are needing your assistance on are 5, 6, 7, and 27. Topics 5, 6, and 7, I've kind of grouped together in my motion. This is a motor vehicle accident between 2 commercial vehicles that happened during Winter Storm Uri in February of 2021. And the allegation is that my defendant driver hit a patch of black ice, slid, struck the center divider on I-35, and his trailer jackknifed out across the lanes where one of the rear tires of the trailer made contact with the plaintiff's commercial vehicle. There were no the EMS was not called. Everybody refused medical treatment. It was not a bad, in my view, it was not a bad collision, but the plaintiffs are now claiming significant injuries. Plaintiff is asking to depose Audubon's corporate rep on the number of collisions that have occurred in the state of Texas over a 3-year period involving its vehicles. And they're similarly asking for Audubon's accident register for a 2-year period of prior collisions. There's nothing about the number of collisions or the accident registers for other accidents that has any relevance to this case. Plaintiffs have not alleged any pattern or practice of accidents involving Audubon or asserted any other claim that would make the wholesale discovery of other accidents somehow relevant. And as for number 7, which I've grouped with the other 2, there's no basis to depose Audubon on the number of power units it operated in the year plus preceding the accident. We just think that those are not relevant and constitute an impermissible fishing expedition. The last topic on which we've not yet been able to reach agreement is topic 27. And again, this is in the same vein. It asks for all lawsuits or claims filed against Audubon regarding quote unquote reasonably similar collisions occurring in the state of Texas over a 3-year period. Again, I don't know what reasonably similar collisions means. I don't think it's reasonable for my client to know what that means. There is, when you're dealing with a corporate rep deposition, there is a reasonable particularity requirement. The Rule 199.2B1 requires that the notice describe with reasonable particularity the matters on which exam is requested. And the rule is patterned after Federal Rule 30B6, which federal courts in Texas have described as the particularity requirement, meaning it requires painstaking specificity. I don't know what a reasonably similar collision is. I don't know how many black ice accidents there might have been in Texas, but I also don't believe that those are relevant in any way to the issues in this particular case. And so we would ask that those 4 topics be quashed from the deposition notice.
Thank you very much. Response, Mr. Kusurek?
Yes, Your Honor. Numbers 5, 6, and 7, what plaintiff is trying to discover, and it may not be admissible, but for purposes of discovery, similar to how the defendant discovered information about my client's driving history through an abstract and asking him questions about his driving history going back to 2012, more than 10 years, or about 10 years before the accident. We're trying to discover some information about this trucking company's safety record. And so we've narrowly tailored, topic number 5 to the state of Texas. And this company, I believe they're in Canada. I'm not mistaken. I know Ms. Meltzer can correct me, but they're a over-the-road interstate trucking carrier that operates in multiple states and jurisdictions. And we're just trying to focus on the state of Texas. This man was involved in an accident, the driver of the Audubon tractor trailer, when he was returning from Laredo to Michigan, and the accident occurred near Austin. The accident was in February of 2021. We've asked for the years 2019, 2020, January and February of 2021. So less than 2.5 years is the limitation there. This information is important because, if the company takes a position that we're an industry leader, we're a safe company, I can't rebut that unless I know other information about how other drivers might have been involved in accidents. If there's other accidents involving inclement weather like the one we have here, where this 18-wheeler probably shouldn't have even been on the road, when he jackknifed his truck and then ran into my client and knocked him off the road. That's important for us to know. Is the company being responsive to drivers getting involved in other accidents in the same conditions? And we've limited again to the state of Texas. It also goes to establishing a pattern of practice. I have not specifically alleged that in the pleading because I don't have that evidence yet. And it may not be there, but we're entitled to discover it. And so for those reasons, Your Honor, we believe that 5, 6, and 7 should be allowed to go forward in the deposition of the corporate representative. As to the fourth topic, number 27.
You know what, if you wouldn't mind, Mr. Kasurek, Ms. Melcher, let me just handle these one at a time.
Okay.
In terms of response and rebuttal. Is there anything else you would like to add, Ms. Melcher? Is this unreasonably burdensome, or is there some reason why your client can't do just a quick search on Texas responsive documents from 2019, 2020, and just that early first 2 months of 2021?
Our allegation is, our objection is not that it's burdensome. It is that it is overbroad and not relevant to any claim in the lawsuit. If plaintiff wants to know about other accidents involving this specific driver, which they've already done discovery on, and he doesn't have any other accidents, that's that to me is a perfectly reasonable subject of inquiry. But I don't think there's any basis for the wholesale discovery of other accidents involving this large trucking company. I just don't see the relevance to this specific accident or to any of plaintiff's claims or defenses in this case.
Okay.
If I may real quick, Your Honor, that would go to inadequate training policies, policies regarding supervision and monitoring. If they have other drivers, and I don't know until I know the number of accidents, number of units, but a high percentage of other people getting involved in collisions in Texas during this 2-year period, it could be relevant and it might be admissible.
Okay, let me give it some thought, and you may move on to the second request, Mr. Kasurek.
Okay, and that would be, so that was discussed. Well, that was kind of 5, 6, and 7 together. But just to recap 6 and 7, the accident register will again disclose the number of accidents that the company has had during the period 2020 to the date of the collision, so 2 months of 2021. That's only a 14-month period. For that same 14-month period, how many power units do they have on the road? I want to know what percentage of their fleet is being involved in collisions. Do you want me to continue on to the number?
Well, let me just ask this. I mean, what basis, what exists that leads you to the concern or suspicion or whatever it is that you believe that's leading you to believe, other than just a fishing expedition, that this company has a large number of incidences that may be a pattern or a practice?
Certainly. So through discovery, I learned that Autobahn would administer driving tests. These are written knowledge tests to the drivers. Mr. Morrow, the defendant driver in this matter, completed a handful of those exams. They were never graded by the company. When I went online and found the answers, he failed. He wrote down he got 100. Apparently turned it into the company. They produced it in this case. We also have the defendant's expert acknowledging that their driver was not following the Federal Motor Carrier Safety Administration's rules regarding how to classify his hours. For example, instead of saying he's on duty driving, he's logging his hours as personal conveyance. So there is, and he even worked for this company more than once, 2 different time periods. And so I don't think this company is following its own policies and practices on paper. I don't think they're supervising their drivers. I don't think he was actually trained to do what he's doing. I think it could have happened in other situations based upon what I've seen in this case.
Okay. Ms. Meltzer, anything else you wish to add?
Yes, just that, Your Honor, there are other topics in this deposition notice that would cover all of the subjects that Mr. Kasurek just mentioned. These are pertaining to collisions, the number of collisions, the number of accidents, none of which has to do with directly has to do with training. This particular driver has not had another accident. So I just think it's a fishing expedition.
Okay. The motion to quash with respect to 5, 6, and 7 is overruled. However, or denied, but with respect to those requests, they shall be limited to, for number 6, we're just going to have that 14-month period. With respect to 5, 2019, 2020, and January and February of 2021, you'll have to provide me with some additional information on the scope and limitation requested for 7, Mr. Kusurik.
Okay. There are on number 7. It's meant to track the information sought in number 6. So number 6, that 14-month period, other collisions. Number 7 is how many units did you have out there? For a company that has 2 units, 1 collision is 50% of their fleet. For a company that has 500 units, I don't know what Autobahn has. It might be a much smaller percentage. I just don't know.
Okay. So you're only asking for 2020 and January and February 2021 for that request?
Right. For 6 and 7, it's limited to January 1, 2020 through the date of the collision, which was February 17th, 2021.
Okay. Okay. And it shall have that limitation, that 14-month limitation for number 7. Next bucket, if you
Your
will.
Honor, may I just clarify?
Sure.
For topic number 5, is that also limited to the 14-month period?
Well, so that was the number of collisions and the request was a little bit longer. But yes, I think for the purpose of today, I'm going to limit it to that 14-month period. Mr. Kusurik, if you want to.
No, that's fine, Your Honor.
Okay.
Agree.
Okay, so all
Thank you.
3 of those will have that 14-month limitation. Thank you all. Next section. Is number 27 the next request? Okay. Your response on that one?
My response, Your Honor, is that we've sought to limit this question, seeking information about other lawsuits and claims filed against Autobahn, both geographically, state of Texas, scope reasonably similar, and by that I mean, and as I communicated Ms. Meltzer before, situations where the tractor trailer has lost control of this vehicle in inclement weather and then hit another vehicle involving collision. And then time we've limited to 2019, 2020, 21. And the reason I'm seeking this information is the company providing training to its drivers? Is it adequate training? Are they being responsive to other accidents involving similar accidents in the state of Texas, where these tractor trailers probably shouldn't be on the road? If it's an ice storm, they shouldn't be there.
Okay.
Your Honor, I would just point out that the plaintiff was also driving a commercial motor vehicle in the same conditions and at the same speed as my driver. But the issue with this topic is that reasonably similar collisions is not defined. Inclement weather, are we talking ice storms? Are we talking highway accident? What exactly does reasonably similar collisions mean? And again, how is that relevant to this specific accident, to the facts of this specific accident, to the plaintiff's claims in this specific accident?
Well, let's look at what the petition is in this case, or at least the allegations in the petition are.
And Your Honor, I'd be happy to revise that topic from reasonably similar to inclement weather. And
Okay.
just for further understanding, my client was, it might be classified as a commercial motor vehicle, but he was driving a Dodge pickup truck, not an 18-wheeler.
Okay. All right. So as long as the request is narrowed in scope to the state of Texas and incidences involving inclement weather, then the motion to quash would be denied as long as the scope of the request is modified to reflect those changes.
Yes, Your Honor.
So once again, Your Honor, to clarify, inclement weather, can that mean wind, rain? Or are we talking about ice or snow?
Inclement weather should be any incident in which weather was alleged to be the cause of the accident.
Thank you, Your Honor.
Sure. Anything else I can help you with today before I excuse you all?
Not from plaintiff, Your Honor.
Ms. Meltzer,
No, thank you, Your Honor.
Mr. Peterson.
No, thank you.
All right, you guys have a good weekend. Thank you very much. And if you have a proposed order for the court, I'm happy to sign off on it. If you want to reach an agreement by Rule 11, that's also fine. Just whatever is easier for you all.
I'll circulate one, Your Honor, and then
Okay.
submit.
Very good.
Thank
Take
you, Your
care.
Honor.
And your excuse. Take care.
Thank you.
Mhm. All right, let's go ahead and get Ms. Donnelly into the courtroom.
Good morning, Your Honor.
Good morning. I can't see you. There you are. Okay, very good. Welcome back. This is Rocket Mortgage versus Pucaris. And this is your motion for default judgment, and you may proceed when you're ready.
Thank you, Your Honor. Yes, Rachel Donnelly, on behalf of petitioner Rocket Mortgage. This is a default under Rule 736, home equity loan. Response due date was January the 23rd, 2023. No response has been filed. The loan has been in default since May 1st, 2022. We served them of the notice of hearing. It was delivered at the property address.
Okay, so let's walk through this. This looks
Yes,
like
Your
a reverse mortgage, so I'm suspecting this is an elderly person. Do you know if Martha Kakarik is, do you know her age?
No, Your Honor. I
Okay.
don't know her age. I would have to look into that.
Okay, it looks like that you served the occupant of the home generically, as well as her, at 2500 Dove Drive. Back, looks like on the 7th day of December 2022 at 10 a.m. Is that right?
Yes, Your Honor. On the 736s, I believe it's served via the district clerk, regular and certified mail to both of the respondents and the occupant per
Oh,
Rule 736.
Okay, I see that. I can't, it would be remiss if I didn't say as a judge how difficult these are for the court to see.
Yes, sir.
That the legislature has chosen to make these obligatory for the courts, and judges do have very, very little discretion in these matters, that people are notified by first class mail. That just means a letter coming in the mail, doesn't, Ms. Donnelly? And that means that the occupant may have missed that mail, but that is what the law says. I know that you're doing and you're following the law on behalf of your client, and the court will have to follow the law as well. But I do take these very, very seriously. They're concerning to me. Foreclosure on a home based on, mail going is pretty scary. So let's just make sure that everything has been done properly.
Yes, Your Honor.
I see the return of citation has been on file properly since December 7th, 2022. I do see that I don't know who Brian is, but looks like he signed that. You also sent the registered mail, and that's also on file.
Mhm.
That was Article 70, 21, 27, 20, 00, 00, 2040, 1002. He did sign it. Looks like somebody received it by registered mail.
And he must, because he's Demetrius Brian, so he must go by Brian.
It looks like that because I can see
Mhm.
that was how it was sent.
Yes, Your Honor.
There is a military status affidavit on file related to both Martha and Demetrius Byron.
Byron, yes, Your Honor.
Looks like you checked those. Neither of them were in the military as of February 3rd, 2023. And you have put the last known mailing address in the court's file, so that'll go to them as well.
One clarification, Your Honor. I believe you said it was a reverse mortgage. I believe this was just a standard home equity loan.
Okay, it must have populated as reverse when in the system. That's how it
Right.
shows for me.
Right.
I see what you're saying.
I just wanted to clarify that.
Okay, yeah, it looks like just a Quicken loan, regular mortgage. Is that what you're seeing?
Home equity,
Oh,
just a
home.
Texas home equity. Yes.
Got it. Okay, it looks like you've done everything according to, oh, hold on one second. My court, it looks like Ms. Donnelly that we've just done a very quick search, and Ms. Kokaris has passed away. She has a obituary that is readily found on Weed, Corley, Fish, Funeral Homes, and Cremation Services. I cannot act with respect to her.
Okay, Your Honor.
Okay, it does look like her spouse is Demetrius,
Mhm.
but I think we need to just reset here, given the fact I don't have jurisdiction over her at all. So I'm not going to grant it as to her.
Okay, and we didn't know that she was passed, Your Honor. We do have death searches running, but I guess it did not pick up her passing, and I will look up the obituary.
Okay, yeah, it looks like she passed way back in January 5th, 2018, before this was even filed. So I probably
2018, yeah. So
it was
4 years has lapsed, but somebody did pay on it until May of last year. So
okay.
okay,
We're gonna
appreciate
have
it,
to,
Honor.
sure. Well, thank you. And thanks to Ms. Whitlow Huang, who did that search for the court and found that quickly. And what do you want me to do as of today? I'm not going to grant the default judgment, obviously, today.
Of course. Mhm.
But once,
Pass on the hearing, and we'll have to go back and do some research and find out the status of her death and to see if there's any probate or anything. We did
perfect.
not know about that.
Okay, perfect. We'll note that in the court's docket notes so that we know that that you're doing that search and trying to figure out if there's a probate pending, and you can just let the court know if and when you decide to dismiss, and if not, what action that you plan to take. You're gonna amend the pleadings or anything, okay?
Okay. Thank you, Your Honor.
Okay, take care, Ms. Donnelly. Have a good rest of the week.
You too. Thank you. May I be excused.
You are. Thank you.
Thank you.
Okay, well, let's bring the last case in. Okay, very good. Thank you all for your patience. I don't see Mr. Blanton back quite yet. Is he there or is he stepped away? Looks like he may have stepped away. Let's go ahead and just take a 10-minute there you are. Mr. Blanton, are you ready?
Good morning, Your Honor. Yes.
Good morning. Welcome back for your motion for summary judgment.
Yes.
I have let Judge Meacham know that you all that I granted the continuance and you all are going to be set June 24th. Mr. Vavra was there with her, so court admin knows that, but you'll still need to set the case on that docket, as I'm sure that you all know. And I'm ready for the motion for summary judgment.
Excellent. May I proceed, Your Honor?
You may.
Excellent. This is Chris Blanton on behalf of Omni Management Hotel Corporation. I represent Omni Barton Creek. This is an interesting case where Mr. Melendez's client was a guest of the hotel. It's the hotel golf course on the date of the incident. He was provided a club car, golf cart through our pro shop. And while he was on the course, the Crenshaw golf course, he took a turn below the number 2 tee box, which has a change in elevation below the box. And during the course of his descent down the change in elevation, the golf cart entered into a slide, fell onto its left side, fell onto Mr. Arnold, and Mr. Arnold sustained a non-displaced, non-surgical compression fracture at L1. And subsequent thereto, this lawsuit generated, and here we are today. The plaintiff has made lots of allegations, and I think the basic point to start from with respect to this MSJ would be to consider the plaintiff's live pleading. The live pleading is the 5th amended original petition. My assistant yesterday uploaded a copy of the petition as well as the relevant case law that I'm about to discuss with the court. So wherever the box is, if the court has access to it, the court can find the materials I'm about to discuss, and they're highlighted as well, and made to where it's user friendly, if you will. So in any event, the golf cart falls. So plaintiff files his lawsuit. We have the 5th amended original petition, and in it, plaintiff makes a number of allegations, all of which revolve around the same allegation, and that is the golf cart in question, as well as the entire Omni club car fleet at the time and up to today, had a software package installed into it called Visage. So every golf cart has Visage installed into it, and that is a software package that does neat things. So in each golf cart, you got a little monitor, it looks like an iPad, if you will, that gives information to golfers. They can order cocktails, they can figure out the distance to pins, they can figure out the course layout, all sorts of neat data. That also, the Visage system also does a couple of other things, including it will pop up warning signs if there's something, caution signs if something's about to happen, a change in elevation, for example, or if the course has determined to be, cart path only, like if there's a rainstorm. So the software package has an ability to regulate the golf cart's speed via GPS across the fleet, as well as where the carts can go off the course, on the course, wherever. And all of this involved this proprietary software called Visage that is linked into the governor and the motherboard of the golf cart itself. So this is all about a software package, and to what extent it controls and how it regulates the operation of a golf cart. The golf cart itself, like your car, your vehicle, it has a computer that controls a lot of things, And then boil it all down, there are basic mechanical systems involved in your vehicle. So you have computer and mechanical, and the question of how they interact is interesting, and how they interrelate, to what extent they do. Very interesting question. So anyway, in this case, if you look at the plaintiff's petition, the plaintiff contends that on this date of this incident, the golf cart had Visage installed. And as Mr. Arnold descended the change in elevation, Visage dropped his speed, as it did everyone's speed. It was a zone of action where every golf cart that went through that area dropped in speed from 13 miles per hour to 10 miles per hour to 7 miles per hour through the application or the operation of the Visage software. That's what the facts are. And plaintiff contends that because the Visage software was in operation and in the process of slowing him in his speed, he, quote unquote, touched the brakes, which then caused Visage to lock his brakes, creating a slide in the golf cart, causing it to fall inside. So there's this allegation that the premise of the plaintiff's case is that the golf cart in question was defective because it had Visage software installed into it. And that software, when active, caused the brakes. I'm sorry about the popping up. Caused the brakes to lock on his golf cart. The brakes, the mechanical brake system. So if you look to the petition, that's exactly what the plaintiff says. I uploaded it. Obviously, it's part of the court's record, but I uploaded it. So I highlighted the multiple times in the petition where the plaintiff, mentions allegations in the facts. It's a very brief factual. It's a one-page factual statement, and then in the cause of action, there's a statement right here. And in it, the factual allegations continuously state our golf cart was defective because it had a software system that disabled the golf carts while on premises and could cause the golf cart brakes to lock up if the system attempted to slow the golf cart as the person operating the golf cart simultaneously touched the brakes. So it's a very specific petition in which the plaintiff specifically says, my theory is that the golf cart had a software system installed that could control the brakes. And on the date in question, it did control the brakes because Mr. Arnold, I touched the brake and it caused the cart to enter into a slide. It's a very complex, it's a scientific allegation. It's not a simple allegation. It's an allegation that involves complex concepts that most jurors wouldn't know and understand. That is, what's the interplay between Visage, the Visage software system, and the brakes? Do they interact? Are they interrelated? Does Visage in any way have any ability to control the braking system? Is there any relationship? So we filed a motion for summary judgment, and we attacked all of the plaintiff's causes of action, with the exception that the plaintiff brings up a good point, that I attacked his negligent entrustment claim. I'd never heard of negligent entrustment of a defective vehicle before. That's apparently a cause of action I've never heard of. As I grew up in law school, I'm a 27-year lawyer. I've never come across a cause of action of negligent entrustment of a defective vehicle. And it's probably because the three cases the plaintiff relies upon all date back to the 1930s and 40s, but it's out there, and I can see that it does exist. But I drafted my motion where when I responded to, I attacked his negligence claim, I attacked it as a premises claim, I attacked it as a negligent entrustment claim that I'm used to, and I may have misspoke with respect to how I argued that, because I'm used to negligent entrustment being, I give a vehicle to somebody who I should have known as a reckless driver, incompetent driver, or whatnot. And I scratched my head, and I didn't know this negligent entrustment of a defective vehicle claim. But be that as it may, I drafted my summary judgment motion, and I attacked causation and negligence in this case. And right out of the gate, if you read my motion says, look, plaintiff can't meet his burden whatsoever because he has no scientific evidence whatsoever. He has no expert evidence. He has no expert testimony and no expert opinion, no expert who's going to come in and render an opinion about this complex relationship between Visage, or lack of a relationship, which I'll get to, between Visage and the braking system of a golf cart. And without that, they can't, the plaintiff cannot prove causation without an expert on this issue. I don't know, maybe your honor knows, maybe your honor's backwards and forwards knowledge, has backwards and forwards knowledge of club car and how the software packages work and things under the hood of a golf cart. I certainly don't. And if the court doesn't, I suspect nobody on the jury is going to have that kind of information either, about how all this stuff works. So plaintiff has not designated a single expert with respect to the operation of Visage and how it controls, how it operates a cart. Now, I move for no evidence summary judgment. I attack all causes of action on the basis that plaintiff can't prove that we had a duty and that we breached it. And he can't prove he can't prove that we breached it because he can't show that there is that Visage somehow rendered the golf cart to be defective. That is, the plaintiff still has to show that this golf cart is defective for all of his causes of action, whether however he couches it and however he names it, but however he names the causes of action. He can't prove causation in this case that the cart was defective because he lacks the expert to do so. I asserted this motion as a no evidence motion, saying, plaintiff, it's time for you, put the proof in the pudding, show up and tell me where your evidence is that this golf cart was defective. Prove to me that you have more than a scintilla of evidence that this golf cart was defective. Because if he can't prove the golf cart is defective, then pack up the tents and go home. It's over. So plaintiff produces three pieces of evidence, if you will. Number one, he attaches the deposition transcript of a guy named Murdoch. Murdoch is a golf pro. Luther Murdoch is a golf pro at Omni. He's an Omni employee. And before he starts talking about Luther Murdoch's testimony, in his response, plaintiff says, "Look, Luther Murdoch's our expert. Your own expert said this. Your own employee is our expert," which is an implicit or a tacit admission that you got to have an expert witness to prove this case up. So plaintiff says in his response, "We have an expert. We're going to rely upon your guy." So they cite for the court some testimony in the response, which is incomplete. And our reply tried to line out why it was incomplete. There was some confusing back and forth going between plaintiff's lawyer, Mr. Melendez, and Mr. Murdoch. And I tried for the court to simplify it and put everything into context as to why it all matters. I mean, the court has a recitation that number one is incomplete because it stops before Mr. Murdoch, in the plaintiff's evidence, summary judgment evidence, the recitation provided for the court, or the citation provided for the court, stops when Mr. Melendez wants it to stop. But if the court continues to read on, and I have fully fleshed that out in our reply, Mr. Murdoch goes on to state that he says, look, at any point in time when the Visage system is operating, if a customer touches the brake or a client hits the brakes could lock up. All right, boom. On that, the court may go, wow, that's an implication that together, Visage operating and a guest hitting the brakes, wow, together contemporaneously, that causes something to happen. No, that's not what it's saying. If you read Mr. Murdoch's testimony, the evidence relied upon by an expert, as plaintiff calls him, Mr. Murdoch says, look, if Visage is operating ... and someone hits the brakes could lock up. And that's what Mr. Murdoch is saying. The brakes could lock up if someone hits the brakes, irrespective of whether Visage is operating. But the plaintiff has offered Mr. Murdoch's testimony to prove that Visage must be defective, must have rendered the cart to be defective. So I have cited in the reply Mr. Murdoch's testimony, and he goes, if you hit the brakes, then he means hitting the brakes will lock up the tires. Question: if you're hitting the brakes while Visage is trying to slow it down, question, it can lock up the tires whether Visage is slowing the cart down or not. Okay, hold on. Are you saying that even if you don't intend to lock up the brakes and you just press the brake pedal lightly, the cart knows you're going down a steep hill and it will lock them? No. Question, it depends on the operator, right? Right. I mean, the operator's always in control. So plaintiff has the first leg that plaintiff stands on to respond to our no evidence motion that plaintiff has no evidence the cart's defective is our golf pro. And he's proffered that testimony to prove a point that doesn't exist, that if Visage is operating, it somehow creates a scenario where if you tap the brakes will lock up. That's not what Mr. Murdoch said. There's confusing testimony that's before the court, but I clarify it in the reply. And we uploaded yesterday our exhibit, our factual background, and the court can look at that and whatnot. But and we also uploaded it for the point of responding to plaintiff's response, their evidence they offer of Mr. Murdoch. But Mr. Murdoch says very clearly, look, Visage, whether it's operating or not, is irrelevant. It comes down to whether or not a guy hits the brakes. Visage could be in operation, and if a guy hits the brakes and presses them down, the brakes are going to lock up, irrespective of whether Visage is operating or not. And that's what Mr. Murdoch's testimony is. Mr. Murdoch has been declared an expert by the plaintiff, again, tacitly implying that you have to have an expert to prove this kind of stuff up. And what he says is, hey, look, brother, it's irrespective of whether or not Visage is in operation, it's slowing down a cart or whatever. If you hit the brakes, if you hit the brakes, operators in control, operation of putting pressure on the brake could lock the brakes. And so the testimony in the response that the court will see is ambiguous. I clarify it in the reply because I provide, pursuant to the rule of optional completeness, the full picture of what the testimony is. So that's the first tidbit of information offered by plaintiff to survive the no evidence summary judgment motion, that they can't raise a genuine issue of fact that the golf cart itself was defective. And their allegations the golf cart's defective is intertwined in every cause of action they bring, including the gross negligence claim. So they can't prove through Luther Murdoch that the cart was defective. That's not a scintilla of evidence. Mr. Murdoch's testimony does not. If you read the reply and read all the evidence, if you read the evidence produced by plaintiff, as well as the complete evidence we've supplemented with, Mr. Murdoch's testimony doesn't get them down the road, doesn't kick the can down the road. So that's the first thing they rely upon. The second thing they rely upon is some testimony of Mr. Murdoch again, coupled with the testimony of a guy named Benedetti. Mr. Benedetti was a golf cart assistant at the course at the time. When Mr. Melendez took Mr. Murdoch, the golf pro's deposition, Mr. Murdoch said, I think there was another incident there a few months earlier at that same location. And it was a guy, it involved one of our employees, Mr. Benedetti, Bob Benedetti. Bob Benedetti came around that corner and he turned his golf cart over right there, that same location the plaintiff did. And the plaintiff is now offering that testimony from Mr. Murdoch as evidence that there's some evidence, there's scintilla of evidence that the golf carts are defective because the Visage software causes carts to fall over or turn over in that location. Well, the problem with that is the testimony relied upon by plaintiff of Mr. Murdoch, talking about the Benedetti incident, is that Mr. Murdoch says, all Mr. Murdoch says is, yeah, Benedetti, it's my recollection that a guy named Bob Benedetti turned a cart over there and he came to me and he said, hey, I was driving too fast. It's my fault. I did this. This is my fault. I screwed up and I want to pay for it. Let's not make a big deal out of this. I don't want to lose my job. All right. That's a far cry from Mr. Benedetti. Mr. Murdoch testified that Mr. Benedetti said, Visage kicked in, the brakes, when I touched the brakes, because Visage was there, it locked up my wheels. I entered into a slide and the car fell over, which is consistent with what the plaintiff is arguing in this case, that Visage applied, hit the brakes, caused the cart to enter into a slide and fall over. Mr. Murdoch didn't say that. So Mr. Melendez, doing his due diligence, good lawyer, he deposes Mr. Benedetti. Mr. Benedetti comes across as great, and he provides the Benedetti testimony attached as his summary judgment evidence. His point number 2, the Benedetti incident and the evidence and the deposition of Mr. Benedetti. Mr. Benedetti said this. That's in my reply. That never happened. I was never involved in an incident whatsoever that involved a cart turning over. Never turned a cart over in my entire life. And Mr. Benedetti testified to that. So the second leg upon which the plaintiff responds to the motion for summary judgment falls, because that second leg is Mr. Murdoch's testimony that Benedetti supposedly turned a cart over in that area. And as far as Mr. Murdoch knows, that was because of speed. And that's what Benedetti told him. But when you ask Mr. Benedetti, Mr. Benedetti says, I have no clue what you're talking about. This is news to me. I was never involved in any kind of situation. So we provided that follow-up testimony to the court in our reply, and it's there for the court to see in the Dropbox. The third thing is that earlier the morning, and this is the big one, this is important. The third leg and final leg the plaintiff stands on to challenge to try to establish a genuine issue of material fact is that earlier that morning, a well-regarded an oncologist there in San Antonio, Austin, experienced, but maybe 10 golfers or 10 golf groups earlier that had traveled to the area experienced a similar situation where his golf cart fell into its side as well. And plaintiff argues that because of that incident, that creates a genuine issue of material fact to believe that the golf cart itself is defective, or the system, the Visage system, again, GPS, fleet-wide, it rendered every golf cart defective because Dr. Eric Greffel, earlier that morning experienced the same problem. That is the same issue where he reported that the golf cart the brakes locked up on it, causing the cart to enter into a slide, and it fell over onto its left side, right in the exact location. The testimony offered, though, by plaintiff of Dr. Greffel is just an exchange of 3 questions, and it's in the response. The 3 questions he asked them all assume that Visage can control the brakes. So when the court looks at the Dr. Greffel testimony, the third leg upon which the plaintiff stands in responding, the Dr. Greffel testimony, each question assumes and includes in the predicate of the question. So did you know that when Visage operates, it could cause a golf cart to lock up its brakes? Each of those 3 questions, I objected to. There's an objection form, and you'll see it. And Mr. Melendez was open and honest when he quoted the text of the deposition, and he included my objection forms in there and objections leading. The questions that were presented were objectionable because they assume, or they outright represent that Visage can control the brakes. And
Mr. Melendez, I have to interrupt you because you've gone well over your time. Mr. Melendez, this is a no evidence motion for summary judgment. I have to give Mr. Melendez, who has the burden here, an opportunity to present his evidence.
You bet.
Okay, so just wrap up. That's okay. I just need you to get to
I'll wrap up in one minute. Okay, so with respect to the evidence, I'll certainly sit down and let Mr. Melendez talk. Bigger picture, the housekeeping issues. Plaintiff has sued 2 other entities, TRT and an entity that doesn't exist. He didn't respond, and in the motion we move, of course, that those entities should be dismissed. And there was no response with respect to those. There's no response filed with respect to that argument. So those 2 other entities should be wiped out. Third, and finally, there's no evidence whatsoever to support gross negligence. And that would include the whole defective golf cart theory. So please, thank you, Your Honor. I do appreciate your time, and I'm sorry for overspeaking.
Sure. Thank you very much. Which entity specifically are you moving on?
That would be, I get passionate, Your Honor, and I talk a lot. So, all right.
She didn't want us to be here till midnight. Okay.
I'm a defense lawyer, and I get paid by that. I get paid by the hour. The 2 entities are Omni Barton Creek, Inc. Omni Barton Creek, Inc. and TRT Holdings, Inc.
Okay. Thank you.
Thank you, Judge.
Thank you very much. Mr. Melendez, your response.
Okay, Your Honor. The only thing he got right is when he said he missed the boat. because he didn't just miss one vote, he missed a whole fleet of votes when it comes to what we're here today about. This is a summary judgment motion. And the one thing that we even pointed out in our SIR reply is not in any of his motions, nor in any of his arguments today, did he tell you what element of our negligent entrustment of a defective vehicle he is implicating. He rests and relies upon this house of cards that we need an expert and we don't have an expert. So the first thing that I just want to go ahead and tell you is we do have an expert, Your Honor. We designated Mr. Luther Murdoch, the golf pro, as our non-retained expert. So almost every single argument that he makes that we don't have an expert for any of this falls on that, number one.
On causation, I mean, he did spend some time addressing his concerns about lack of evidence of causation.
Okay, however, what I want to do, and I pulled them up for you, and I'd like to share my screen with you,
Sure.
is I'd like you to understand, though, that the basis and support that he uses when it comes to case law are on product liability cases. Not a single negligent entrustment of a defective vehicle case does he have, or does anyone exist that requires an expert on causation. And because here's the difference, Your Honor, like in the Mack Trucks case, let me go ahead and show that to you, the one that he's cited as requiring causation. This was a product liability case that was arguing a design defect against the manufacturer of a product. And that court rightly held, and here it is on 583, a lay juror's general experience and common knowledge did not extend to whether design defects, such as those alleged in this case, cause releases of diesel fuel during a rollover accident. Okay, those are, again, product liability cases. This is not a product liability case, Your Honor. And when he said he didn't realize that there was a negligent entrustment of a defective vehicle cause of action out there, that's another boat that he missed, because we've pled that from the very beginning. And although he didn't realize that there was a negligent entrustment of a defective vehicle cause of action, the Texas pattern jury charge, and don't worry, Your Honor, that's already an exhibit to our response. It's PJC section 10.13 is a well-recognized, a well-established cause of action already in PJC since I've gotten out of law school and continuously in the 2020 pattern jury charge. And so I just want to also make sure that the court understands the difference between, what I guess potentially, but we didn't plead, a product liability case against maybe a Visage software company. They're not a defendant in this case, Your Honor.
Well, let me ask you this though. When you do look at the pattern jury charge, what elements are included?
It is entrusting the vehicle to another if the entruster knew or should have known that the vehicle was defective.
Okay, and how will you explain to the jury that the vehicle was defective?
Using their own golf pro expert who was familiar with this scenario, that if that software that they control, Your Honor, what they do is they're allowed to establish speed parameters on how much, once they engage the software on a zone in their golf course, it will reduce the speed of the golf cart to, and when that zone will actually engage and actually do that to the golf course. So the golf pro is in control of all those things. And what he explains to me under oath is that they learned of a scenario before these incidents, and again, incidents plural, that if the software is slowing the cart down and the operator just, and these are his own words, and I'm going to show them to you, just touches the brakes. Let me go and share my screen so you can see this testimony. If you're going down a hill and the cart starts to slow down and you may think you're going too fast, if you touch the brakes it could lock up the tires at that point. If you don't touch the brakes, then the tires shouldn't lock up. So I asked him, so I think what you're telling me is if you also anticipated slowing down yourself and you're going to hit the brakes, if at the same time you're doing that and Visage is trying to slow it down, it will lock up the tires. Yeah, Yeah, if you hit the brakes, then it will lock up the tires.
Okay, thank you.
So Judge, the other thing that he's completely leaving out when I say he's missing the boat is that this is not a product liability case. This is more like the negligent entrustment of a defective vehicle precedent cases that we have in our reply, where you've got a father, for example, which is one of our cases, who lends his vehicle to his son with bad brakes. The brakes cause a car wreck, and now the father is sued for negligent entrustment of a defective vehicle. Those cases don't require that that the plaintiffs come up with an engineer to tell you how the brakes work. That's not what this is about. This is about the person lending the vehicle's knowledge that it has that issue. You don't have to.
And you have that in your fifth amended petition, I see in paragraph 11.
Judge, I've pled negligent entrustment of a defective vehicle the entire time. Yeah, I had some other ones there, like premises liability.
We don't need to go into what
Right.
happened before the fifth amended. We just have that before me, and I just wanted to make sure that was there in your petition, and I see it in the pleadings. And you've shown me what you expect to prove at trial, and Texas pattern jury charge, which is what's reasonably expected to be in the charge and what is required to be proved at trial. So that's fine on that. Gross negligence and these other entities, can you just go through those two pieces with me? Omni Creek Inc. and TRT.
Right. So they are all in control and are on the lease for having the ability to have superior control of lending the carts to the actual entities. But he does not implicate that element. He does not say in his summary judgment motion that any of these defendants did not have control of the cart. So that's why I start with my first explanation as to why he misses the boat. He doesn't implicate those elements at all, Your Honor. He just comes up with, he needs an expert. If you look at a summary judgment motion, he doesn't ever say these entities are not in control of the carts. These entities do not own the carts. Ever does he say that?
Let me look at the motion. Give me 1 second.
Look at footnote number 1, Your Honor.
Footnote number 1. Where will I find footnote number 1?
Page 1.
Page 1. Okay. Plaintiff originally sued two incorrect entities.
I mean, Judge, even the motion has one defendant on it and just lists that defendant as the movant. Not 3 defendants, but 1.
Okay, well, that's probably enough to defeat that request. You're only moving for summary judgment by defendant Omni Hotels Management Corporation. So I don't have the motion that you described, Mr. Blanton. I don't have that before me.
Footnote number 1, we're joining in. They join in and expressly incorporate each and every paragraph of this motion.
I don't think you can do that through a defendant's no evidence motion for summary judgment. I don't think that that's the appropriate vehicle to do what you're trying to do. It may be that it needs to be moved at some point through another motion by those entities if you have responded on their behalf.
Sure.
But I don't think you can, in a footnote in a no evidence motion for summary judgment. I just don't think that's an appropriate.
Understood, Your Honor. Understood. And with the court's continuance, perhaps we will we'll clear that matter up.
Okay, so I'm going to take that and just correct me if I'm wrong, but I'm taking that as a withdrawal of the request to seek a no evidence motion for summary judgment with respect to Omni Barton Creek Inc. and TRT Holdings Inc. Is that correct?
That's correct, Your Honor. Thank you so much.
Okay, very good. And that moves us to the gross negligence, MSJ.
So this is, and again, he's trying to say that we still don't have an expert, which I think we have dissolved pretty easily because that's not required. But just to give you some background on this, when he was talking about Mr. Benedetti was actually, according to Mr. Luther, who's the golf pro, is the first person that had a flip behind the number 2 tee box at Crenshaw in the 3-month period after they now install this Visage software. He's right that when I deposed Mr. Benedetti, he said, hey, that wasn't me. So I can't tell you definitively it was Mr. Benedetti, but this still goes to the knowledge that these people have about how carts are flipping in that exact same area, because Benedetti's was going down the hill behind the steep cart path behind tee box number 2. 65 minutes before Mr. Arnold's cart locks as he's going downhill and then flips on him, a club member by the name of Dr. Eric Greffel, who I deposed, says the exact same thing happens to him. And it's in their incident reports. They say it's the exact same scenario. So now we've got 2, Your Honor, before a 1,000-pound cart flips onto Mr. Arnold, fractures his L1, herniates 4 discs in his spine under L1. And so they know how much these carts weigh. They know this is about to be the 3rd flip on top of an unsuspecting customer. And they testified, or Mr. Luther testifies, it would take him seconds to simply disable the zone, have it slow them down before they start going downhill, so that if they lock, it's not while they're just streaming downhill. And now this is the 3rd flip on someone. So do they have reason to know of a serious risk of injury? Absolutely, Your Honor. Do they have the ability with the testimony is that Benedetti, again, Benedetti says it wasn't him, but the point is that Murdoch knows another employee has had a cart flip on him in the exact same area, even before Dr. Greffel, even before Mr. Arnold. The point is the knowledge. So the gross negligence evidence is 2 cart flips before Mr. Arnold. They don't warn them. They don't change the zone. And here it is again, boom, another 1,000-pound cart flips on somebody, fractures his spine. I mean, this is a very serious injury. Dr. Greffel, when I deposed him, says, I could have been hurt too. It just didn't fall on me. And in fact, Dr. Greffel's son was with him. He would just happen to be on his buddy's cart when the cart flipped on him.
Well, let me ask you this, and because there are literally hundreds of pages of documents that I need to read and have not had a chance to do that before your hearing. I need to know from you, where in the summary judgment evidence will I find some evidence, a scintilla of evidence to support that the defendant knew or should have known, had actual knowledge of the high risk of injury that you just described?
Sure. It's in Luther Murdoch's deposition testimony about his knowledge that Benedetti had already flipped a month or 2 before. Greffel flips 65 minutes before, and how much he knows how much these vehicles weigh, and that what that degree of force will be falling onto a 3rd unsuspecting person. So
Okay.
it's in Luther Murdoch's deposition.
Okay. And as I mentioned, I still need to do some reading before I can make rulings on the general negligent entrustment and gross negligence motions for no evidence motions for summary judgment, or the motion for summary judgment as to those 3 pieces. Is there anything else you want to direct my attention to make sure that I look at? Yes, Mr. Melendez.
One last thing is
Sure.
this. The case law is clear that when a summary judgment movement does not clearly implicate what element of a plaintiff's cause of action that they are moving for, it turns their motion into a traditional motion for summary judgment where they have the burden of proof on every single element of our cause of action of negligent entrustment of defective vehicle. That's all I wanted to point out, because this explanation is all over the place. The motion is all over the place and doesn't even state which element of our cause of action it's implicating. That's it.
Very good. Thank you, Mr. Melendez. Mr. Blanton, any last words? It's your motion.
Real briefly, Your Honor, that this case, well, you were showing the PJC for this negligent entrustment of a defective vehicle claim, and you asked Mr. Melendez what the elements are. The elements are in black letter in that PJC, and that is negligent entrustment of a defective vehicle. Plaintiff and we've challenged that from the get-go throughout our entire motion, that plaintiff has no evidence that this vehicle, this golf cart was defective. The burden of proof is on the plaintiff or his element to prove his cause of action, to bring forth a scintilla of evidence that the vehicle, the golf cart, was indeed defective. And that is something that requires scientific, mechanical, specialized knowledge. The testimony that Mr. Melendez relies upon of Mr. Murdoch is incomplete with respect to what the court was shown. Again, the reply has the remainder of Mr. Murdoch's discussion and what he's trying to say and what he does say. So please, when the court does read the briefing, please note that. And then finally, the fact that an accident happens, two things. The fact that an accident happens is not evidence of itself that something is defective. That's well settled Texas law. And then this case should be treated like any other unintended acceleration case in Texas. The Texas Supreme Court has made it very clear that in unintended acceleration cases, I think we all in law school recall a case called Henderson. What was it? Henderson versus Ford Motor Company. We probably all remember that case from torts. It's an unintended acceleration Texas case. This is an unintended deceleration case, if you will. And when it comes down to the decision in the Supreme Court case of this Nissan case, which is, let me get the case to the court site real quick, if I may. The Supreme Court in, scroll. The Supreme Court in 2004 in Nissan versus Armstrong, which is 145 Southwest 3rd, 131, 145 Southwest 3rd, 131. It's uploaded for the court and highlighted into the Dropbox. When there's these unintended acceleration cases in Texas, the Supreme Court has always held that expert testimony is necessary to differentiate between whether or not there's some sort of defect in the vehicle or some sort of problem with the vehicle versus a person hitting the gas. And this is exactly the same situation, whether the brakes are applied, to what extent the brakes are applied, because at the end of the day, Visage does not control brakes. There's no evidence that Visage has anything to do with the brake system of a car. With that, I'll sit down and rest. Thank you, Your Honor.
Well, I think I have to ask you to direct the court to what element of the cause of action, which is included in the Fifth Amended Original Petition. That's what is before the court. What element of negligent entrustment of a defective vehicle? That's the cause of action. He rises or falls on that cause of action and gross negligent entrustment. On which element are you moving for no evidence motion for summary judgment?
No evidence that the vehicle was defective.
Okay. Okay, so I am going to take the motion under advisement and I will get you a ruling as quickly as I can. We have a new trial date and I have communicated that to both our local administrative judge Meacham as well as our court administrator, Mr. Vavra. Make sure that you get that set on the docket and that you announce properly for your trial setting. It is expected to be a 5-day trial and they are aware of that. And I wish you all the best. You'll get my ruling as quickly as I can get through the briefing and get you a ruling. It shouldn't take too long. Okay, certainly within the next 3 weeks.
Thank you, Your Honor. And as Your Honor is reviewing it, remember, as the court has pointed out, my brief at the time was written based upon several other causes of action that no longer are in play. So perhaps if the court is
I can assure you the court won't spend time on the portions of the motion that you've withdrawn or that for which Mr. Melendez has no longer asserted causes of action. I'm not going to spend any time. Won't make rulings on those. That isn't to say that my order won't include just clarifying. And to that point, you should both provide your proposed orders to the court, and they should include that either the causes of action are no longer before the court if they were part of your motion, but are no longer part of the Fifth Amendment petition, or that the portion of your motion was withdrawn, as is the case with the entities. Those should be clear in the order. Just help the court by including those things in your proposed order so that they don't get forgotten. Okay.
Certainly, Judge. Thank you so
Okay.
much.
You all take good care and have a good weekend, and we'll see you when you come back for trial.
Take care.
Bye-bye.
Bye-bye.